Eu abro para as questões agora. Talvez a gente possa fazer 2 blocos de 3 perguntas. E eu peço que, por favor, levante as mãos. Quem queira.
So thank you. The presentations were excellent. I really enjoyed all of them. I had a few, well, I would like to engage with a conversation with all of you about that. We'll do that later. So I think 3 main points. First to Laura, in relation to Elge's presentation as well, I think that experiences does not necessarily mean identities. And I think this came very strongly from what Elge said and less a bit from your research. And I'm wondering, first of all, whether you also, in addition to the interviews, looked at the judgments of the judges that you talked to, because at times a personal story does not necessarily reflect in action. So I'm wondering whether you did some kind of research on that aspect. And when I'm thinking of judges in Israel, I think that the most progressive judges in respect of human rights and even feminist agendas are white men, but who came from NGOs. So they came from a background of awareness, of rights talk, of feminism that they were exposed to in their NGOs work. That does not mean that identity does not matter. But I think it does mean that perhaps we're placing too much emphasis on identity and less emphasis on the employment background, voluntary work, other sorts of experiences that can affect judges much more than identity necessarily. At least in the third step that you also mentioned, which is the reflexive view, which is needed in order to make such judgments important. So I would like to get your input on that. My second question is to Shreya, which I found your argument really interesting, especially what you said, that the further you are from the norm, the harder it's to get remedy. I thought that was really important. But I wonder whether the intersectionality approach that you're proposing can be done in a legal system which is really liberal in essence. And I'm thinking of, Martha Feynman's work on vulnerable subjects, where she said, we tried this, we were there, we did that. It's still, liberal feminism. And the law thinks in a liberal way. So I'm wondering whether you think that we can really change the paradigm view within the legal system, or perhaps we should take more steps from down below. So just one initiative that's happening in Israel is policies led by NGOs to further diversity in workplaces by encouraging employers to adopt diversity policies within large firms and within workplaces. So, all these efforts that are coming from below might be much more effective in achieving the goal that you wish for than perhaps the legal system. I'm wondering what your input on that. Thanks.
Thank you. I enjoyed those very much. I think I'm really following on from Einat. I really wanted to push Laura and Elsha a little bit, the kind of feminism experience divide or not divide. Because on the one hand, Laura seemed to be arguing that, I think, that the experience of being a woman, what was coming out of your interviews, the experience of being a woman, of having a sense of what it is to be raped, even if you're not a feminist, or what it is to be a mother, even if you're not a feminist, brings a different set of experiences into the discussion, and that is in and of itself important. On the other hand, Elsha seemed to be suggesting that you do need to be feminist to make an impact. I'm not sure she necessarily thinks that, but that's what came across. So it's really just to hear from both of you as to how you put those two together. And then Shreya, just a quick question. I often think there's a difference between what judges say and what they do. And in a sense, I think that some of the constitutional court cases are about intersectional groups. So if you think about Bay, for example, they're just not saying it. They're using a kind of liberal way out of saying, well, it's sufficient that we only find discrimination on one ground, and they say, well, it's gender and it's this and it's that. But in fact, the group is an intersectional group that is getting the benefit. And I just wondered about your comments on that.
So perhaps I put my question in English in order to facilitate the communication. I know it's a huge question. It's also a conceptual question related to the presentations of Sharia and Laura. And I appreciated very much the presentations, but I'd like to try to bring some interdisciplinary inputs into discussion as a sociologist. At the level of sociology, we are trying to abandon the concept of identity. Identity is a concept more used in the classical and anthropology and sociology in favor of a concept of position or positionality. So if you understand identity as the departing point for a position in a field of power, you have to understand these identities as a binary identity, as a fixed identity, and also as identity that is stable. In different situations, you have the same identity being reproduced. And this means that if you try to understand gender relations or racial relations, you have to see actors like women and men, and in the other case, black and white, or the other racial groups that are defined as fixed categories. In another view of this field, working with the concept of positionality, you have multiple, not identities, but identifications that are produced within politics, not before politics, as supposed by the concept of identity, but in politics itself. So you don't have pre-political identities, you have political positions constructed in fields of power. The consequence of that, to understand intersectionality, is very broad. So you don't have intersectionality as a crossing of different binary identities, but you have a complex field of power in which persons, individuals, groups are fighting for resources and for power. In that case, you can explain, also Elsie showed in the case of the judgment of Oscar Pistorius, why a black woman made such decision, because this decision is not based on the identities, but on a position in a field of power. So it's just, I know, it's an input for the discussion. I don't expect a closed answer. My question could be how to translate this complex concept of positionality or positions into legal terms. So just a small question.
Bom, acho que a gente pode seguir a ordem das questões, né? Pode começar com a Laura.
Well, thank you very much for those questions. A lot to think about. And I think I might start with Kathy's question on...
Laura.
Please, this one. Is that on? Is that on? Yeah, that's on. So Kathy's question on feminist or not feminist, and feminist versus experience. And so I started my project 4 years ago at the date of publication almost exactly of the English Feminist Judgments Project. And so this was something that was very conscious in my mind. Was I going to continue and use feminists as the key point for my research, or was I going to use women? And I decided to, I think the Feminist Judgments Project is wonderful. I'm participating in an Irish variation of it at the moment. that. But I decided that for my research I was going to look at women, simply because I think that the contestation around what is feminist and what is not feminist was quite difficult. Also because I was doing empirical work, and some judges would maybe not want to self-identify as feminists, and so it might make data collection a bit more elusive in my work. And I also thought that what I was trying to get at with my research, and what I've come to the conclusion at the end, is that what matters is a plurality of experiences. I'm not looking for a particular outcome. Rather, what I'm saying is that courts, and I look at appellate courts, and appellate courts are strongest when the marketplace of ideas amongst everybody sitting around that table is the largest, and so the most different from each other. So I was not necessarily looking for the feminist experience, but rather experiences that diverged from each other to the greatest extent. And at your questions with judgments, so reflecting on the judgments. So I did, I came to interviews actually after looking at judgments. So in my master's thesis, I just did an analysis of the judgment writing of the European Court of Human Rights, and looked in that on whether or not I could find gendered experiences or gendered expressions coming through in those decisions. And I could find some, but not all. And I felt that it was an important methodology to then go and interview judges in this respect, because a lot of them would say that it's in the debate and in the discussion that happens behind closed doors that impacts upon the result, and it might not be directly articulated in the final production of the judgment, but that debate has somehow shaped the judgment. So it might not be very explicit, or the debate may have lost, so the person positing you are not getting, this perception on the case, or I'm a woman and I understand this in a different way because of my background, and therefore you should listen to me. Well, maybe they weren't listened to and it didn't make the final judgment, but that didn't mean it wasn't impacting in some way on the decision-making process. I didn't track directly the judgments of my interviewees with the interviews that I did. That would have been an interesting exercise, but also a difficult exercise, because the judges were very reticent to talk explicitly or to give direct references to their own judgments. They would sort of talk in generalities rather than about specific cases, for understandable reasons. Identities versus experiences, and was your question, do we focus too much on identities? And less than experiences, yes, and with the NGO judges, so professional experiences is something that I focus a lot on in my doctoral thesis. So a big section of that is training, and particularly for lawyers. We have one thing I should have also said about the stereotypical judge in the United Kingdom, in Australia, and South Africa is also that he is a barrister. He is an advocate. So it's coming from one specific class of legal practice, and this diversity in legal practice perhaps might be the most important for bringing a diversity in experiences and ideas and perspectives. There was a recent report last week. I've been assisting on a report in the UK on judicial diversity, and one of their recommendations was certainly that we need to look at expanding the pool of professional backgrounds and see that as a really important aspect of diversity. So with experiences and identities, I still wouldn't give up on identities and identity markers altogether, and that is because my thesis focuses on, I put up the 1, 2, 3, 4 categorization of why it matters. So points 1 to 3 were about power, about fairness for women in law, and about institutional legitimacy. And the 4th one was the quality of justice. I think for points 1 to 3, if we don't have women there, we're not making any progress on those. So even if we have a bench full of the most, progressive, fabulous, feminist white men, it still doesn't do anything to address power arguments. Point 4, I think we need to treat identities carefully, and like I said at the end, they need to be the starting point and perhaps a flag post, a point where we might be able to have different experiences, but we cannot assume that there will be different experiences at that point. And And the final question on what we do with positionality and identity and how we transfer positionality into legal language. That is a very difficult one. We're all sitting on this panel as lawyers, and so we talk about identity categories as status grounds, which come from discrimination law, and that's why we have that pull towards them, I guess. But I do think that positionality is very important, and that sort of has, I think, a lot of resonance with what I was saying about experiences, and that experiences are fluid, and that it will matter. I mean, even for the judges, what sort of case you're sitting on will depend on which of your life experiences will come to bear and which will be important for that decision making. What kind of society you're living in will be very important. Yeah, so I might defer to Shreya now to answer the rest of that very difficult question, but I agree with you that it is an important concept to think about. Yeah.
So I'll take them in turn, and thank you so much for the question. I completely agree. I think intersectionality is a domain of everything. It's a domain for sociologists, for anthropologists, for feminist theory, and I'm approaching it as a discrimination lawyer. And you're right, within that space, at every level, it's important to factor intersectionality. What I can give an example as to intersectionality being relevant as something being integrated as a specific legal concept in a legislation and doing good is in the Equality Act 2010 in the UK. There's something called the public sector equality duty. And that's basically to eliminate all forms of discrimination. And that's radical. And I think that definitely will include intersectional discrimination. This is the most insidious form of discrimination. This is the one which is marginalized and invisible. Oh no, great stuff is happening. So the litigation around public sector equality duty is excellent. And I think that form of legal recognition can do good when a good norm is stated. It cannot be undermined. That'll trickle down, and it will inform work of good NGOs. But I do agree, grassroots work is absolutely essential. But just to give a counter example, that good legal norms matter as well. Kathy, on your question. I'm deeply critical of myself for being critical of the South African jurisprudence, because I do believe, exactly as you said, that it's not important to just see what the judges say, but see what they do with what they say. And the South African judges do believe that they were intersectional judgments. So just to rehash this, 2 points again. One is diagnostic. And I think in terms of articulation, it is important because discrimination law is the exact field where we've got to achieve some sort of clarity in being able to say, this happened to me because of. The common causative statement in every discrimination statute or constitution will have that on the ground of, on the basis of, because of, whether it's Title VII in the United States, Article 15 of the Indian Constitution, Article 14 of Section 14 of the Canadian Charter, Section 9 of the South African Constitution. Across the board, I think that causative language means some diagnostic work. I think some sort of articulateness in saying this is why it happened is important, not just for the diagnostic purpose, but more importantly for the expressive purpose. And I think that generally is coming from my work on persons with disabilities. So when the right to integrity was integrated in the United Nations Convention for Persons with Disability, the purpose of right to integrity was that so much of the discourse around persons with disabilities was that they were misunderstood. Their physical and mental integrity was sort of caricaturized. So they wanted to say simply this: recognize and respect us for who we are. And I think that is an expressive function for judicial judgments to be fulfilling. And perhaps that's where the clarity is needed. But I completely agree. South African Constitutional Court has done really good job. And I think one has to be very careful in stating what the problems with those are. The last question, I think it was a fantastic question. Agreeing that so much of work on intersectionality has not been done in law, but from others. I think there's immense amount to learn, and I agree with Laura completely. As lawyers, we're looking at a very small realm, and your question is very critical. This broad understanding of intersectional identities, positionalities, from whichever perspective you're coming from, how to translate that, how to not lose it into the construct of grounds of discrimination, which all of us were hinting at. And I think this is a tough, very tough job for lawyers. So within discrimination law, there are very few markers that, you know, something should be immutable, something should be a fundamental choice, something should be a matter of autonomy, of substantive freedoms, of dignity. So these are the markers on which grounds are formed, and to be able to say certain identity is a ground, discrimination law uses its own. But I think all of us need to work back and forth, especially the lawyers, because intersectionality is very new for the discrimination lawyers and for all of our work. And I think the kind of theories you were referring to are critical to be translated into law. And yeah, thank you.
Okay, I'll try to be brief. I'm going to start with Sergio. Your question on positionality and whether it can be translated into law. Shoo, I don't think so. In a sense, kind of all legal claims are claims for power and for to exercise certain levels of power from particular positions. However, legal discourse is pretty unsophisticated, really. And most legal systems work on a liberal basis in which the concepts of choice and merit and individualism and those kinds of things are directly opposed to seeing things in terms of positionality and how power and disadvantages are produced by positions. So if we can't even at this stage get to grips with a relatively simple concept like intersectionality, maybe, I don't know, 3 centuries will be needed for that. As to the question on the difference between identity and experience, I think Laura and I agree that both are important. I think maybe something that illustrates why I think experience is really so crucial, or theoretical knowledge is in one of the judgments by the Constitutional Court, we had a judge, it was the Masia judgment, it was the judgment on rape, where the men should also be able to be raped. And the judge who wrote the judgment was Judge Maya, I think, and she was an African woman. And you could see that she felt a responsibility to put the gender point across. And she tried very hard. And she came up with something which, to my mind, was just wrong. Not because she didn't mean to do it right, but just because she didn't have the theoretical kind of background to be able to reflect on the consequences and the nuances of the kind of judgment that she made and what it would mean for the development of legal systems or jurisprudence on gender. So I think being a woman, maybe, this is why I used Judge Masipa, I think being a woman and being an African woman in a court maybe puts the responsibility on that woman so that she feels she has to, whilst maybe we need somebody, or maybe we should train them, but maybe somebody who has the feminist background can really think through things and grasp the nettle and come really make a good judgment. I think, for instance, our most radical feminist we've had on the court, and maybe you want to shoot me if you want, was a white man. There is writing which suggests that for white men to articulate feminist concepts is a much safer thing than it is for a woman to do so, because they're far less likely to be accused of being biased. And so there's a certain breadth or leeway for them to articulate feminist concepts in really quite radical ways, whilst the women are sometimes a little bit more careful. So I think both, but I think if we educate them all, then maybe we'd kind of be in a better position. Thanks. Megan, did you want to?
Bom, a gente já está no horário de entrevista para o próximo painel. Bom, a gente já está concluindo, né, para participar do próximo painel, que começa agora às 11 horas. Eu gostaria de agradecer muitíssimo a cada uma das expositoras. Peço desculpas por não acompanhá-las sem a tradução simultânea e agradeço mais uma vez a oportunidade de mediação. Muito obrigada. E eu peço, por favor, que os próximos expositores se aproximem já para que a gente consiga montar a próxima mesa.